Bonjour, Kinamagi and Ireland edition Cass, and welcome to this edition of Social Studies Explorer. Today's edition, A New Nation. Well, you may have considered the United States to be a nation after 1776 or 1783. The truth is it wasn't really a nation at all. It was a grouping of semi-independent states that sometimes worked well together and sometimes didn't. It wasn't strong, and it surely would have eventually been reconquered by someone under the way it was set up. Our Articles of Confederation did give us the Northwest Ordinance, and that Northwest Ordinance is how we determine the rules for becoming states and what territory is where, and really established the plotting of what's now Michigan. As we know, there were a great number of problems with the Articles of Confederation, such as almost having to have everyone agree. And if you've ever sat down trying to figure out what's for dinner, that doesn't work ever. So if a household of four can't determine what's for dinner, what do you think the chances were that the United States would be able to come to an agreement on anything of value, especially with such heavy issues as taxation and slavery looming over that? So we decided to create a new constitution. And the Constitutional Convention really comes out of a meeting about trade. And some of the states weren't happy. They were like, what? This wasn't supposed to be the way, what we were talking about. But eventually, with people like George Washington involved, it becomes pretty clear that, yep, we're going to do this. There were a number of compromises. Some of them make sense, such as a bicameral uh, legislature. That means two houses, such as in this case, the Senate and the House of Representatives, that kind of spoke to the views of both the large and the small states. And rather depressing compromises, such as a three-fifth compromise, where enslaved persons weren't even a full person. There was a lot of debate over the issue of federalism versus limited government. The Federalists wanted a relatively strong central government that could make decisions and guide the new nation, whereas the Anti-Federalists wanted a limited government that was really powerless to do anything and for the power to lie with the states. There would be eventually ratification, which means they had the minimum number of states to say, yep, we're good with this. But that didn't make all of the issues go away. There were a number of public issues, such as the lack of a Bill of Rights, what rights the states would have, and what to do with the issue of slavery. Those amendments in the Bill of Rights would include things such as the freedom of religion, or at least the idea of the freedom of religion, freedom of speech, and the right to a fair and public trial. The Bill of Rights was influenced by colonial experiences, especially Amendments 1 to 4. They took their experiences under the Crown and said, hey, we don't want these things to happen here. Let's make rules. There's a word in here when we get to the amendment about quartering. And a quarter is, in this case, is not a unit of money worth 25 cents, but means to provide shelter and supplies to soldiers. You may have heard the term somebody's quarters. Quarter can refer to housing. All right, the first thing we're going to do, and you have this on your paper, and you're going to do this independently, and then we'll kind of talk about it. What I'm going to ask you to do is after I read these to you, I want you to pause the video and write down what you think these quotations mean. We will then review it. This will be done on the paper copy and will not be a part of the Google form. First one, Jefferson and Madison, December 20th, 1787. Let me add that a Bill of Rights is what people are entitled to against every government on earth, general or particular, and that no just government should refuse. So when you get to it, you're going to write, what does this mean in your words? It doesn't have to be as long either. And please don't make it longer. I want you to summarize that idea. Madison to Jefferson, April 22nd, 1788. Should this, the demand for a Bill of Rights, be carried in the affirmative, I think the Constitution and the Union will both be endangered. So what is Madison saying to Jefferson? And then on the flip side, Jefferson back to Madison in March of 1789. I am much pleased with the prospect that a Declaration of Rights will be added, and hope it will be done in the way which will not endanger the whole frame of the government or any essential part of it. If while doing this you need to know what a word means, you can use resources such as m-w.com or Google the term. I want you to pause the video, write down what you think these mean, and then when you're done, unpause the video. All right, welcome back. Let's compare your answers to what the answers provided by the text. The first one, let me add that a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse. The meaning of this is Jefferson is saying that a Bill of Rights is absolutely necessary. He's saying that no fair government should refuse to give people a Bill of Rights. You could probably simplify that even further, saying Bill of Rights is necessary and government should give it to the people, or something to that nature. Madison to Jefferson, should this, the demand for a Bill of Rights, be carried in the affirmative, I think the Constitution and the Union will both be endangered. Madison is saying that he thinks the addition of a Bill of Rights would be dangerous for the country. He is saying it's not needed. So he said Madison is suggesting that it would be dangerous. That would be another way of phrasing it. And Jefferson to Madison, I am much pleased with the prospect that a Declaration of Rights will be added, and hope it will be done in the way which will not endanger the whole frame of the government or any essential part. Jefferson is saying he's happy to hear that a Bill of Rights will be added to the Constitution. He's saying that he hopes it will be written in a way that will not be dangerous to the way the government is organized. All right, so let's again review our Bill of Rights here. Bill of Rights. No, I don't own the rights to that song, but now it's stuck in your head too. Amendment 1, freedom of religion, freedom of speech, freedom of the press, freedom for people to gather peacefully, freedom for people to send petitions to their government. What this means is we can express ourselves how we want within reason. No, freedom of speech does not guarantee you the right to make threats against somebody, but it does give you the permission to say, I disagree with the government without the government automatically arresting you. Now, keep in mind, many people are confused that when an employer might fire them, if you walk out and say something really, really bad, your boss might fire you. It's not freedom from consequences, it's freedom from the government punishing you for that speech. But again, it doesn't guarantee you the right to threaten someone or anything negative like that. Freedom of religion, again, was the idea that you can practice any religion you want or none at all. It's taken a lot of time for that one to really be implemented. It was by the late 70s or 80s, before some of the Native American ceremonies were no longer made illegal. Freedom of the press means the newspaper can publish stories that are critical of the government. Freedom for people to get together peacefully. That's our right to protest. There are some limitations. If you decide that you're just going to go stand in the middle of the street to protest, there will probably be consequences. But there are opportunities to do this with some limits. And the freedom for people to send petitions means we can ask the government to change things. Doesn't mean they're going to do it, but we could ask. Second Amendment states that in order to have a prepared military, people are guaranteed to keep the right to keep and bear arms. Keep in mind, in the 1780s and early 90s, our country is a far different country. Our military was largely a patchwork of different militias. And obviously, there was no desire to have a standing military in their cities. We had the British for that. We didn't want to do it with our own military. There is a lot of debate about this today, about what did the founding fathers mean and what does well-regulated mean as part of that. The courts will continue to rule on this probably as long as I'm alive. Amendment 3 states the government cannot force people to house and feed soldiers in their homes during times of peace. This is the idea about not having to issue quarters. An example of this, let's say the U.S. military wanted to be in Michigan. They might knock on my door and say, yo, get out. We're taking this place. Without compensation. It's not for defense. That's no longer allowed. British did that a lot in places like Boston. Amendment 4, people, their homes, or their belongings are protected from unreasonable searches or seizures. It's the idea that the state needs a warrant unless they see something dangerous happening. They can't just come in and start snooping around just to see if there's anything they can find on you. They actually have to have basically a permission slip from a judge, and then they can come to the door and check out your stuff. But the idea is that they can't do it just because they feel like it. There has to be a reason. Amendment 5 guarantees a person accused of serious crimes the right to be charged by a grand jury. It also states that people cannot be forced to give evidence against themselves. If a person is found not guilty of a crime, he or she cannot be put on trial for the same crime again. And the federal government cannot not unfairly take people's lives, freedom, or property. Okay, a lot of stuff in there for an amendment that you hear quite often when we talk about legal cases. A grand jury is an individual or small group of people that look at evidence and say, yeah, there's a possibility that this person committed a crime, in which case then a prosecutor would introduce the charges and would go into the legal process. It also gives the right for, well, we'll move on to that one, for people not to testify against themselves. You can't put someone on the stand and say, did you do it? They're not forced to say, yeah. Or if they had actually committed the crime, you can't get them to have to say, to lie, and then also charge them with perjury later. Most people are not going to admit to a crime on the stand. Otherwise, they probably would have done something called a plea bargain, where they say, okay, well, I'll admit it if you lessen the charges and we'll compromise here. If a person is found not guilty, you can't put them on the trial for the same crime again. This is called double jeopardy. This protects people from being accused of the exact same crime 27 times. Now, it doesn't mean that if you can never be charged for any crime, but not for one in that specific incident. And finally, the last part, it kind of talks about cruel and unusual punishment. If I walked across the street at something other than the crosswalk and they got me for jaywalking, they can't put me to death, or they can't take everything I own or lock me up for 60 years. It has to be reasonable. That's where that word unfairly, because we know that in some cases, the federal government or some states do have capital punishment. We know some people are locked up for the rest of their lives. and sometimes the government is allowed to compensate or compensate, take away your property without compensation for in lieu of crimes. Amendment 6 guarantees a speedy and public trial by an impartial jury if a person is accused of a crime. The accused person also has the right to be told what they are accused of, and they have the right to a lawyer. They also have the right to see and to question those people who have accused them. Having a jury trial means that the defense only has to convince one person that it didn't happen to not be convicted. Whereas with a bench trial, the judge is either going to agree or disagree. Gives you a little better odds, because the jury does have to come to a full agreement that you're guilty. Now, they have to come to a full agreement that you're not guilty, and that sometimes leads to what's called a hung jury, where they determine that they're not going to be able to find an agreement. And in a lot of smaller cases, that makes the case go away because prosecutors don't want to keep spending money in hopes of getting a conviction. Now, on bigger trials or for crimes like murder, they quite likely will try it again. You have the right to a lawyer. In fact, it's very much encouraged. They say that people who are their own lawyer have a fool for a client, because most people aren't versed in the law and knowing how to apply it to defend themselves, whereas a lawyer is expected to do that. You also have the right to question the witnesses and make sure that they're telling the truth. Amendment 7 guarantees a trial by jury in civil cases, which are cases that involve a dispute between private parties or between the government and a private party. These aren't criminal matters, but they include things like if somebody sues somebody, you can ask for a jury there where the jury has to decide, well, who should be paying up? It's much different than the TV shows like Judge Mathis or People's Court, where there's one person. You can have a jury. Amendment 8 says that the courts cannot use cruel or unusual punishment or set bail and fines that are too high. Going back to my example of jaywalking, they can't say, well, until your trial, you're going to have, if you want to get out, you're going to have to pay $1 million for jaywalking. It does not mean that they have to give you bail. In the case of something at a murder trial, quite often they'll say, nope, you're going to stay locked up until after the trial. Amendment 9 states that people have other rights that are not stated here. That's the idea, and that was part of the original discussion of the Bill of Rights is this an exhaustive list? Clearly it's not. The Ninth Amendment basically acknowledges that there are more rights than are here. And the absence of the right in the Bill of the Rights does not mean you don't have that right. Amendment 10 states that the people have all the rights not given to the United States government or forbidden to state governments by the Constitution. And by the people, we mean the state government. If the U.S. Constitution doesn't tell a state they can't do this, such as, things like printing money, then they can do it. This is also the basis of many arguments. It was the argument that states used to join the Confederacy or to support things like slavery. Quite often, the states' rights is argued for when they want to do something that it may not be as popular, but other times can be used just in the background of, okay, the U.S., the federal government isn't building schools, so then the state will. All right, so you're going to have an assignment today, and you're going to be encouraged to use any of your resources, including Google. What event, freedom of religion, is there a time in our colonial history where we didn't have freedom of religion? You just need to list the colonial issue. You don't necessarily have to create a detailed explanation. A lot of these are from these are all from the first 4 amendments. So think about what you've heard, what you've read, throughout this year, and just write down what event motivated this. This will be completed via paper copy if you're in class, even though you are welcome to use a Google search if necessary. If you are at home, you're going to fill out the Google form. If you have any questions, please reach out to me at mireland@sitechipschool.net. Otherwise, have a minwag minwa bamapi.